Yesterday, the Supreme Court of Nigeria temporarily halted the move by the federal government to ban the use of the old Naira notes from February 10. The 7-member panel suspended the move in a ruling in an ex parte application brought by 3 northern states of Kaduna, Kogi, and Zamfara. The 3 states had argued that the note swap plan was causing hardship before the elections. Justice John Nyangokoro said the decision to suspend the deadline was unanimous. However, the application being ex parte was not served on the Attorney General of the Federation, who is sued in the case as the representative of the federal government. In a phone chat with Arise News, the Attorney General of the Federation and Minister of Justice Abubakar Malami explained that he is still studying the Supreme Court ruling and that after weighing the options, a decision will be reached by the federal government. The AGF also disclosed that the federal government will likely reach a decision on the matter today. Joining us now on the show to analyze the judgment of the Supreme Court is Dele Farotimi, a lawyer. Dele, good morning. Thank you for joining us.
Good morning, Prof. Since everybody is promoting themselves, let me also promote you to Prof. Doc. Good morning.
Don't worry. Maybe at the appropriate time, I will go back to where I came from. And try to see if I can take a
morning,
chair.
Prof.
Anyway, good morning. Good to have you on the program. Quickly, your take on the ruling yesterday by the Supreme Court in the matter of Kogi, Kaduna, and Zamfara states, invoking the original jurisdiction of the Supreme Court with regard to the February 10 deadline and the extension of grace period to February 17 concerning old
good morning, Rufai.
And new notes.
Let me enter all the proper caveats. Let me enter all the proper caveats. I stopped practicing law 5 years ago, but I do have some legal training. And it's also refreshing to be discussing something different from politics. At least that's a different town hall. So let's talk a little bit of law. Now, it is trite, at least what I remember from my days in the law school, is that when a court is going to make an order, the proper parties must be before it. It must have jurisdiction. It would appear to me in this case that that hasn't happened. The CBN is a creation of law, an act. It is not an adjunct of the president's office. And indeed, the finance minister was told exactly how much power she has in relation to the supervision of the CBN when the order for the Naira swap was originally issued. So what has happened is a situation where the Supreme Court has given an order where it has no jurisdiction. That is my own retired lawyer's view. So when you look at this, you have no choice but to immediately conclude that the Supreme Court has acted outside, way, way, way outside of its jurisdiction. That is one. But when you now consider the fact that we are a country that has been blessed with an exceedingly diligent, honest, and upright police force, honesty that has extended also into our customs, our immigration, and practically every aspect of our national life, I wonder exactly why we expect our Supreme Court or judiciary as a whole to be peopled by angels. Our Supreme Court is a reflection of the Nigerian society. I am being very careful and deliberate in my choice of words because the country is already inflamed enough as it is, and it would appear as if some people are intent on goading the citizenry into anarchy. So I do not want to be one of those that will pour petrol, but this is a most irresponsible action. Now, let me say this. If one is to look at this pronouncement of the Supreme Court, it can only be explained on one of 2 grounds. Insofar as the facts in the public domain are clear, which is that there is an order purporting to halt the deadline, and this order was given without the CBN having been made a party, it would be a most irresponsible order to have given in the absence of the CBN as a party to the suit. That is one. The second thing is, you can only explain this on the ground of incompetence or corruption. That is my own honest opinion. And I stand by those words. And it wouldn't be the first time where the Supreme Court will purport to assume jurisdiction where it has none. These are my views, and I stand by them, and I have used those words deliberately and intentionally. Thank you very much.
Okay, Mr. Farotimi, you see, one of the legal, there was a paper that, because a lot of stories are flying around now, so there was a paper, I think it was the Wheel, that reported that there was a CBN opinion that came out yesterday. And the opinion was, this doesn't concern us because we're not adhered to the suit. We just continue with what we're doing. And in all of this, I want you to also speak to the independence of the CBN, because a lot of people, you know, in this spirit of political ragamuffin, junketing attitudes, think that the CBN is not even independent.
Rufai, our rulers, the Nigerian ruling class as a whole, are a bunch of pyromaniacs. They enjoy setting fire to the house, and they imagine that if the house should begin to burn, it will not touch them. The CBN opinion, I haven't seen it, but fact of the matter is that opinion will be completely correct. The CBN is a creation of law. As a creation of law, it has the capacity, the powers to act independently of the presidency, the legislature, or even the judiciary, insofar as it acts within the law. In this case, the CBN is not a party to the suit. We're even talking about the Supreme Court assuming original jurisdiction. That can only happen in a dispute between the state government and an agency, or in fact, the federal government itself. We're talking about a situation where, let's say, ABC, A being the state government, Malami and his own people, his crowd, the federal government being B, and the CBN is C. So A has dragged B to court and is demanding that C, who was not in the court, who is independent of B, should not do something when he's not even a party to the suit in the first place. It is tried. You don't even need to be a professor of law. You don't even need to be a PhD holder like Dr. Abati to know this. Is simple, elementary. So when you see look, the DSS went before a court and asked for an ex parte order so that it might arrest Emefiele. This was at the beginning of this madness. The court declined. And then Emefiele started his James Bond hide and seek up and down the place. Nobody knew where he was. They knew where he was. Next thing, soldiers are guarding him. DSS are... So they started all these games. This is what I mean when I talk about pyromaniacs. They don't think of the long-term consequences and effects on the institution and the state itself. They are focused on their stupid, narrow interest at all times. And this is what is happening again. So, DSS refused, and the court refused. It is the same game that they haven't stopped playing, that you are seeing again. It is a logical thing. Some people are bent on frustrating the Naira swap policy. They believe themselves to be the target of that policy. Now, I don't know what happens within the APC coven. I've never been in Aso Rock. I've never been anywhere near Emilokon and his coven. But fact is this, it is playing out in the public space, and you are seeing the same thing playing out, unfortunately, in what should be the hallowed chambers of justice. Look, our situation is obvious for any honest person to see. The interest of the average man on the street does not matter in the calculations of those who rule Nigeria. But you see, this is my employer behind me. the guy in the portrait, is a laborer. He has given me a charge, and I must tell you all the truth. This is not about us. It's about them. They're playing their games. It's about who becomes the president. Oh, they are fighting me. It's because of me they are changing Naira. It's because of me the fuel is scarce. What about all the insecurity, all the things that have been happening all these years? Is because of him too? Or is because of us? Who are the victims? So now when they personalize all these afflictions, and then because it affects their narrow interest, they now start fighting dirty, and you start seeing their rump in the marketplace. This has not covered the Supreme Court in glory. But it should tell all of us the extent of the putrefaction that has seeped into our society. It stinks. That is all it does. It stinks to high heavens. And we should be honest enough to tell ourselves the truth. It stinks.
Okay. I think I would like you to assist us with a number of clarifications. When we talk about jurisdiction, yes, jurisdiction goes to the heart of the authority of the court, which can be raised before, during, and after a particular case. And when you raise the matters of jurisdiction, it can affect whatever the court has done in terms of proceedings. Okay, but in this particular case,
true,
what is being talked about is original jurisdiction of the court, of this apex court, under Section 232. And what the states are saying in terms of course of action is that in terms of this policy, they disagree with the federal government of Nigeria. What the federal government and the Attorney General of the Federation is now saying is that, oh, look, this matter should have started at the High Court, not at the level of the Supreme Court. Do you expect that if they push that argument before the Supreme Court will reverse itself on the matter of jurisdiction when the Supreme Court can itself make laws and give interpretation to the Constitution? That's number one. Number two, you raised the point about the CBN not being joined as a party. Now, if you look at the CBN Act 2007, the CBN is in actual fact, apart from this point about independence, an agent of the federal government, with the president giving delegated authority under Section 5 of the same 1999 Constitution. If you look at the CBN Act, the CBN is responsible to the president under Section 4, subsection 3, under Section 6, and under Section 19. So there are things that the CBN cannot do without the representation, without the approval, that's what the law says, of the president. So if in this case the respondent is the Attorney General of the Federation, and the Attorney General of the Federation himself is acting on behalf of the government of the Federation and by extension the president, so where does the issue arise about saying the CBN has not been joined? The CBN Act cannot be superior to Section 5 or to Section 232 or to Section 230, as it were. If you can help us clarify this conundrum.
I know you have a plethora of learned silks who would begin to dab and dissect through the many laws that you have quoted. But let me strip it to its bare bones. And this is the bare bone. The subject is about jurisdiction. And jurisdiction goes to the root of any powers that the court might care to assume. A case was taken before the Federal High Court on the same subject, and the Federal High Court correctly ruled that he had no powers. In my own opinion, as I have said, I am not a practicing lawyer. Now, where the CBN has acted even outside of its powers, it must necessarily be a party in a suit directed at its action or inaction. Where you have a situation where a matter such as this one that has drawn public attention, and we must understand that it is not only the letter of the laws, it is the spirit of the law that must be clearly seen to have been observed. We have a situation here where the issue has been politicized to the point where the matter had come into the public space, candidates have been arrogating to themselves some benefits or disadvantages as a function of the policy. Somebody had gone already before the Federal High Court. The Federal High Court has ruled on the subject. We are now talking about the assumption of the original jurisdiction of the Supreme Court. The law is clear as to when and where that original jurisdiction is to be assumed. In this case, in my own opinion, it has not been properly assumed. Now, if you look at the public interest in this situation, the effect on the economy itself, the uncertainties that the country has been thrown into, such an order could not have been made and should not have been made ex parte. These are my own opinions. And I do not believe for 1 second that any exercise of the power in the manner in which it has been exercised now can be justified on the grounds that you have highlighted. I might very well be wrong, but these are my opinions. And I am also a lawyer who has retired. So what I'm saying to you, the languages I have used, the average lawyer would be careful not to use them because he knows that the Supreme Court or the body itself would begin to come down on it because it must preserve the illusion of justice. But this is nothing that can be justified. There is no basis for the assumption of jurisdiction here, in my opinion.
So, two things. What was supposed to be the proper jurisdiction? Is it the argument that it was supposed to have started from the Federal High Court in the first place? That's one. Number two.
That is my belief.
So, number two will
That is my belief. This matter had been started in the Federal High Court, and the Federal High Court has ruled on the subject. It has ruled. That is the proper venue for it to have been started. And the proper party was before the Federal High Court. The proper party was before the Federal High Court. That is the argument here.
So another thing,
when you talk about jurisdiction, it is fundamental to the discharge of justice.
Okay, let me also add this to it. So when you check the Federal High Court case, those added were the CBN, 27 deposit money banks, which are key people, to be able to halt this policy. The big question will be, what do you think was the motive behind these lawyers not adding the CBN and the deposit money bank to the suit? And also secondly, in the grand scheme of argument, no, hang on a minute, in the grand scheme of argument, if they are to press further and to make a case for the hardship on their citizens, no recorded occurrence of violence have been had in Zamfara, Kaduna, or Kogi as regards this policy. So what are the arguments here?
Look, Rufai, I've told you already. The Yorubas have a proverb. They say, "Àrùn tó ń ṣẹ̀gbẹ̀fà, òun ló ń ṣọ̀ọ́dúnrún, òun tó ń ṣàbọ̀yàdé, gbogbo ọlọ́yà ló ń ṣe." What ails one of a type ails all. We have this assumption that our judiciary is somehow insulated from what has overtaken us as a people. The fact that this is occurring within what should be the hallowed walls of the Supreme Court equally makes it almost unthinkable that it has been influenced in some ways. But I am saying that the persons who took this before the Supreme Court itself has acted most carelessly in this matter, because the proper parties, the persons who took this before the Supreme Court, didn't do it for anything beyond their own political agenda. And they've been in the public space carelessly making it clear that they consider the policy as being inimical to their own political interests. It's not even, and then if you would recall, days back, the governor of Kaduna was there busy meeting with traders, telling them not to worry about changing their notes, that when the candidate of his party comes to power, the thing will be reversed. They've been very, very vocal and clear about why they are against this policy. And let me ask, we were given, I believe, 90 days in all. India did it in 1 day. Now, what were we waiting for all this while? Why were these cases not taken before the Supreme Court itself, even if it must have gone before the Supreme Court? Why is it happening now? We have these convoluted ideas that there might be a standard for the entire world, but we are entitled to a peculiarly Nigerian standard. 90 days, and we are still busy extending, and then now we are in. Look, there is nothing about public interest here. It's completely about political interest. It is up to the Supreme Court to justify what it has done, because frankly speaking, it has not covered itself in glory with this. For me, there is nothing about these that can be justified in law. That's my honest opinion. Can be discounted, like I said. I'm no longer a lawyer.
Okay, Farotimi, I need you to also assist us with further clarification in this regard. You mentioned the case that was taken to court by 4 political parties at the Federal High Court. Now, what is the status of that particular case now, considering the hierarchy of courts, with the Supreme Court now ruling in the same matter, the rest in both cases, the rest, that's the substance of the case, you know, is the same. So now the Supreme Court, which is a superior court, having ruled, what happens to what happened, what was decided at the level of the High Court? And are you surprised that the state governments did not go to Court of Appeal in that particular matter? They went straight to the Supreme Court. What is the implication in terms of the hierarchy of courts?
Well, we're a country that pretends to be ruled by law. So let's first of all be clear about that. We are not ruled by law, but we pretend to be ruled by law. So it's a kabuki game. So it is not impossible that the almighty Attorney General of Nigeria would say much the same thing as what I've said now, since they appear to have Team A, Team B, and perhaps Team C within that their coven. So it's not impossible that the Honorable Attorney General might issue a declaration, as the CBN has already properly also said in the opinion to which you had alluded, that since the CBN was not a party to this suit, it will rightly disregard the vituperations of the Supreme Court. It's not impossible. But from, again, a retired lawyer's point of view, I believe that the CBN is completely correct. It should ignore this ruling, ex parte order, I should say. And I would also say that those who ignored to go to the Court of Appeal and jumped straight up to the wonderful Supreme Court of Nigeria with its many wonderful decisions, the Supremes have become completely wonderful these days. They have their own reason as well. Time is of essence. If they can't get the election postponed, if they can't get if the naira they have stocked at home, is it me and you that have stocked the naira they are trying to kill? It's not me and you. It's the people who have stocked naira that are busy lamenting. So it's not impossible. We're actually in La La Land. Don't be surprised when Malami comes out with his thing. Okay.
Because all of this is quite looking like a game of Teddy Picker. The question is, which one do you want to pick? So does it mean that going forward now? No, it's a game of Teddy Picker already. And it's a joke, to say the least. So does it mean now that if the CBN raises interest rate tomorrow, the state government can go and say, oh, the interest rate affects my state and my people, then goes to Supreme Court and it gets it? Because this is like the precedent that this is setting. And somebody would have wondered that why didn't the states, for instance, take the federal government, as it's taking it to court now, over issues that are pertinent to the people, to the old people's welfare? Why is it over this matter that is so, because what it means tomorrow is that once interest rate is raised or something, a state governor can say, well, the interest rate affects my people, and he'll get injunction to halt interest rates on monetary policy. So if the monetary policy didn't sit right or somebody didn't say something, but they can summon the court and say, monetary policy, you didn't sit right, you didn't speak properly, I sue you to the Supreme Court. And I get...
It can be that ridiculous.
No, but Dr. Abati, isn't it a game of ridiculousness now?
It can be that ridiculous.
Isn't it a game of ridiculous now? Dele?
Right. Look, doctor just took the word right out of my mouth. There is something we call reductio ad absurdum. That is when you continually break down something until it gets to the point of the ridiculous. And the truth be told, Nigeria has gotten to the point of the ridiculous. When they were done destroying the lower courts, they have their gun sight on the Supremes now. And the Supremes are busy unveiling in public. So let's say this. It is not impossible that we'll get to all those points because it usually starts somewhere. And let's be clear, the putrefaction of our court didn't start yesterday. It started somewhere. It started when we tolerated the elevation of, extremely intelligent men, because that's how the court system works. The politicians, powerful men in society, get to appoint the judges. More or less, that's the reality. So the most brilliant one amongst these ones in the lower court gets elevated to the Court of Appeal. And the same thing happens to the Supreme Court. But the question we have to ask ourselves, that we constantly ignore to ask, these men and women, are they Togolese? Are they Ghanaians? They are Nigerians like me and you. The society we have created has reduced everything to the level of the absurd. That is why I say, even the question you have asked, the responses I'm giving, the outrages anyone at home might be feeling, they are selective outrages. We already live with madness that we have all normalized. So what you are saying in the Supreme Court is the peak of the judicial madness that has overtaken Nigeria. You get it? You get it. That's where we are.
Okay.
Reductio ad absurdum.
Yeah, I don't imagine that we'll get to that ridiculous state. If that happens, then the Supreme Court will be dead.
It always starts somewhere.
And all of us will be in dire straits. But let me bring up another issue, still on the Supreme Court. The decision of the Supreme Court with regard to the Ahmad Lawan case and the Machina case in Yobe North, whereby against the ruling of Justice... no, not against the ruling of Justice Obaseki. The ridiculous position that the court cannot inquire into the affairs of a political party, internal matters of a political party, creating the autocracy of party leaders, whereby they can violate any law. In this case, sections 84, 85 of the Electoral Act, given short shrift. And then you have the Supreme Court saying a man who did not take part in a party primary witnessed by the INEC in line with sections 84, 85 of the Electoral Act is a validly elected person. We have seen it in the Ahmad Lawan case. We have seen it also in Akwa Ibom with Senator Akpabio. That, okay, the Supreme Court makes mistakes. After all, they reverse themselves more or less in the Amici case. But we also saw what the Supreme Court in the Ararume case, in the Oprizodima case, and some other cases. But what do you think is happening to the Supreme Court along the lines of your thought?
Doc, when we started this part, it started with him talking about reductio ad absurdum. And I said clearly that it didn't start today. The putrefaction of our judiciary is part and parcel of what has overtaken Nigeria as a whole. You're talking about the Lawan case. You spoke of the Akpabio one. And it's almost as if these are isolated cases. But the reality that you know, I know, each and every one of us knows, is that the Supreme Court and the Nigerian judiciary as a whole are becoming largely, I don't believe, it's almost impossible to get justice again. But it didn't start yesterday. You just alluded to what happened in Imo State. A man who came forth, I believe, is today sat ensconced in government house, thanks to the Supreme Court. The Machina Lawan case is things to the hair, not to the nose, to the hair. And then you've got the Akpabio one. What you are seeing is judicial anarchy. It just does not appear to make sense, but it didn't start today. I recall when I was on your show, it was in June, I was out of the country, and I was asked a question related to the person who now sits at the CJ today. And I said at the time that the man is either corrupt or incompetent. And I spoke specifically to a case that establishes the position that I had taken at the time. That was in June. How can I possibly be surprised by anything I am saying today when I said that to you in June? This is a situation where we as a people must not be afraid to look in the mirror and tell ourselves the truth. Our society is almost close to 80. You know that former French slave plantation? This was how it began its journey to infamy. The only thing that is saving us is because there is enough for them to share. That is where we are going. When you can no longer trust the judicial institution to do justice. Because I'm saying this, there is no longer any clarity. If the Supreme Court will be ruling on matters where it does not have the rest or the proper parties, eventually, the reductio ad absurdum is already happening. And we are normalizing it by pretending that it is not happening. It's already happening. What we shouldn't see, we're already seeing. And, I mean, come on. These are not things that can be explained as errors. When somebody is willfully doing what they ought to know is wrong, something a first-year law graduate will tell them is wrong. And then, please, the putrefaction didn't start yesterday.
Okay.
And when you say that, if they started today, it will happen tomorrow again. It keeps happening, and every day they keep chipping bits and pieces of the integrity of the court from it. They keep casting away their robes, almost like a striptease in a club. Okay, Dele, I mean, for good measure, I wanted to add you to analyze the Akpabio case too, but we don't have time. But when you talked about Haiti, I just hope it's not Haiti or that Papa Doc Duvalier. But we hope we don't get to that level, all right? But thank you so much for your time. Aren't we close already?
It's fine. It's going to be well with Nigeria. Thank you for your time. This country will be great. It will stand on its feet again.